Okay, part 3, implied covenants of good faith. Every contract contains an implied covenant of good faith and fair dealings. A party may not do anything to unfairly interfere with the other party's rights to receive the benefits of the contract. Good faith is implied in every contract. So let's look at the difference between implied in fact contract and a quasi contract. An implied in fact contract arises from conduct showing mutual assent. So an implied in fact contract arises from conduct. Conduct is the keyword, arising from parties showing mutual intent. So implied in fact contract arises from conduct showing mutual intent. A quasi contract is imposed by the law to prevent unjust enrichment where no contract exists. So if there's no contract, the courts would imply a quasi contract to prevent unjust enrichment. So the main purpose of a quasi contract is to prevent unjust enrichment. Now let's look at UCC express warranty. An express warranty is created by an affirmation of fact, a description, or a sample or model that becomes part of the basis of the bargain. It's an express warranty is created by 1. Affirmation of fact, 2. Description, 3. Sample or model, and all of this becomes part of the basis of the bargain. Opinion or puffery do not create express warranty. Express warranties arise from factual statements. Affirmation of facts, right? Factual statements. Okay, so let's look at implied warranty under the UCC. Implied warranty of merchantability requires goods to be fit for their ordinary purpose. The key word is it requires goods to be fit for their ordinary purpose. Merchantability and fitness are implied warranties. Now, what is fitness? Implied warranty of fitness for a particular purpose arises when the seller knows the buyer's purpose and reliance. So the seller knows what the buyer's purpose is and there's reliance. Then there's fitness for a particular purpose. Now let's look at warranty disclaimers. To disclaim merchantability, the disclaimer must mention merchantability and conspicuous. They must be conspicuous. As is language may disclaim implied warranties unless unconscionable. So if a merchant writes a description and says as is, quote unquote, then that language is disclaiming implied warranty unless unconscionable. Unless that as is not for good faith, is unconscionable, then it cannot disclaim implied warranty. But if it is for good faith, then the implied warranty will be replaced by the as-is language. So the seller would not be held responsible if they use as-is and not unconscionably. Warranty disclaimers must be clear and conspicuous. They must be clear and conspicuous about the warranty. If you're disclaiming, your as-is have to be clear and conspicuous. Now let's look at oral modification and waivers. We saw earlier that modification in common law must be accompanied with consideration, and under the UCC, modification does not need consideration. So now let's look at oral, where there is no oral modification and waiver. A no oral modification clause generally prevents oral changes to a contract. So here, if a clause is stated in the contract that there should be no oral modification, then it prevents any oral changes. Parties cannot change anything to the contract later on. However, a party may waive the clause by conduct or reliance. So a party may waive a clause of a non-oral modification by acting in a certain way or by relying on the other party in a certain way. So with that, we've come to the end of the most highly tested contract essay topics or issues, and I will just quickly do a run to review what we have studied so far. So starting from the bottom up, we have looked at a no oral modification and waiver, and we've seen that with a waiver, with a no oral modification, a party is not allowed to add any oral modification after the contract is created. And a waiver allows for a party to add an oral modification by way of conduct or reliance. And then we also saw warranties. We looked at warranty disclaimers. We saw that warranty disclaimer gives the party the right to do away with the warranty of the implied warranty of merchantability when they have a disclaimer. But we saw that for that disclaimer to be in effect, the party must use the word merchantability, and they must be conspicuous. So when they use words like as is, then it waives the disclaimer unless it is unconscionable. And then we also saw what implied warranty was. And we saw that implied warranty of merchantability requires goods to be fit for a particular purpose. And then we saw that the goods to be fit for a particular purpose, the implied warranty has to arise when the seller know the buyer's purpose and they rely on it. We saw UCC express warranties, right? And we saw that express warranty is an affirmation of fact, a description or a sample or a model that becomes part of the bargain. All right. We also saw the difference between a quasi and implied in fact contract. And we saw that an implied in fact contract arises by way of conduct of the parties. And then we saw that a quasi contract arises by way or non-existence of a contract. So the courts would apply an implied in fact contract where there is no contract that existed. This is to prevent unjust enrichment, or so to prevent unjust enrichment where no contract exists. Yes. So then we saw implied covenant of good faith and fair dealing, right? And we said the implied covenant of good faith and fair dealing is embedded in the contract. A party may not do anything that would unfairly interfere with the other party's rights to receive the benefits of the contract. So they have to act in good faith. Then we looked at parole evidence exceptions, and we saw that there are 4 exceptions to parole evidence, which is fraud, mistake, duress, condition precedent, and also if it can be used to explain ambiguities. That's 5 if you want to say. Then we looked at illegality, like when will a contract become illegal. A contract for illegal purpose are not enforceable. That's the rule. Courts may allow restitution to prevent unjust enrichment. That's what we saw earlier. Then we looked at mistake, and we saw that a contract is voidable for mutual mistake if both parties are mistaken as to basic assumption with a material effect. When we looked at unilateral mistake generally does not excuse performance unless the other party know or should have known of the mistake. So it does not. Unilateral mistake does not, but mutual mistake would. And a unilateral mistake would excuse performance only if the other party knew or should have known that there was a mistake. Then we looked at unconscionability, and we said a court may refuse to enforce a contract if it is unconscionable. And we looked at the fact that unconscionability requires procedural unfairness, and substantial unfairness. Procedural unfairness and substantial unfairness. Then we looked at duress. We saw that under duress, a contract is voidable if it is entered under duress caused by an improper threat, leaving no reasonable alternative, right? And we looked at undue influence to have as keyword unfair prosecution of a vulnerable party by one in a position of dominance. That's undue influence. Unfair prosecution by a vulnerable party by one in a position of dominance. Then we looked at misrepresentation and fraud, and we saw that misrepresentation has as keyword fraudulent or material misrepresentation. When a contract is voidable if assent was induced by fraudulent or material misrepresentation. And we saw that fraudulent misrepresentation makes a contract voidable. Fraud requires a contract to be made by false statements and intent to induce reliance. There was actual reliance and damage. So we looked at capacity. We said a person must have capacity to contract. Contracts with minors are voidable at the option of the minor, except for necessities. So a contract for necessity is not voidable. Okay, and then earlier we looked at UCC remedies available to the buyer, the UCC buyer, and the UCC seller. And we saw that the remedies available to a UCC buyer, there are 5. 1, they can cover. 2, they can recover market damages. 3, they can seek specific performance. 4, they can they can sue for incidental damages. And 5, they can sue for consequential damages. Now, we also looked at UCC seller's remedy, the remedies available to a UCC seller. We said the UCC seller can resell the goods and recover resale damages, or they can recover market damages. Also, they said we looked at a lost volume seller who may recover lost profits. Then we looked at assignment and delegation. We saw that assignment has to do with transfer of rights, while delegation has to do with transfer of duties. And as the rights are assigned, duties are delegated, and both the delegator and the assigner generally remains liable unless there is a novation. Novation is a note stating that the other party has completely taken over. So they releases the parties, or the assigner or the delegator. Now we looked at third-party beneficiaries. We saw that a third-party beneficiary may enforce a contract if they are an intended beneficiary. So we looked at when rights will vest. Rights will vest when the beneficiary assents, relies, or sues under the contract. Great. Then we looked at frustration of purpose, where performance is excused when an unforeseen event substantially frustrates the principal purpose of the contract. That's substantially frustrate the principal purpose of the contract. That's frustration of purpose. Both parties must have known the purpose at formation. So frustration will discharge the duty. That's what we saw. And then impossibility, we looked at the rule which states that performance may also be excused if it becomes commercially impracticable due to extreme difficulty or expense. So when it becomes commercially impracticable due to extreme difficulty or expense, then the party will be excused. We looked at anticipatory repudiation, and the rule was anticipatory repudiation. Anticipatory repudiation occurs when a party makes an unequivocal refusal to perform before performance is due. We looked at the non-breaching party may treat the contract as breach and seek remedies immediately. Then we also saw adequate assurance. So adequate assurance arises when there's reasonable grounds for insecurity. A party may demand adequate assurance of performance. And then we saw that a failure to provide an adequate assurance will be treated as repudiation. Now, no assurance may equal breach. So anticipatory repudiation equals breach. So when you repudiate, then you're breaching. Unequivocal refusal to perform before performance is due. So you refuse to perform before performance is due. That is anticipatory repudiation. occurs when party makes unequivocal refusal to unequivocal. Okay, that is good. Then we looked at material breach. We saw that the material breach excuses a non-breaching party's duty to perform. A material breach excuses a non-breaching party's duty to perform. Then we saw that courts will consider the extent of the benefit deprived, the ability to compensate the non-breaching party, and then the forfeiture, the likelihood of cure and good faith. Forfeiture, likelihood of cure, good faith, ability to compensate, and the benefits, the extent of the benefits that were deprived. That's material breach, elements of material breach. Okay, so we also looked at substantial performance. Substantial performance occurs when a party performs in good faith with only minor defects. Substantial performance prevents forfeiture but allows damages for defects. Okay, then we looked at conduct, or we looked at conditions, So conditions. A condition is an event that must occur before contractual duty arises. Oh yeah, yes, there must be an event that will have to occur before contractual duties would arise. There's express condition, which has to be strictly satisfied, or there is constructive condition, which requires only substantial performance. Okay, and then we saw statute of frauds writings exceptions, right? We saw the exceptions of the statute of fraud writings, which includes part performance, full performance, specially manufactured goods, judicial admission, and main purpose rule. All right, then what else did we do? We looked at remedies, contract remedies. We looked at which are expectation damages. For expectation damages, place the non-breaching party in the position they would have been in had the contract been performed, and damages must be foreseeable, certain, and mitigated. So for specific performance to be available, when the damages have to be inadequate, such as unique goods and land. Okay, so those are remedies. Then we looked at breach and performance. We also saw a material breach excusing the non-breaching parties duty to perform. Substantial performance require performance short of full or in good faith. Then we looked at parole evidence rule, which says when a writing is intended as a final expression, prior or contemporaneous agreement may not be used to contradict the writing, unless it is to show fraud, mistake, ambiguity, fraud, mistake, ambiguity. And then we looked at statute of frauds, where it includes certain contracts which must be signed and must be in writing and signed by both parties. This include marriage, suretyship, 1-year contracts, land, goods price over 500 and above. Then we looked at promissory estoppel. We saw that a promise is enforced if there is 1, a promise, 2, reliance, 3, actual reasonable reliance and actual reliance, and then 4, injustice can only be avoided by enforcement. Then we saw definition, the rule for modification, which at common law, contract modification requires new consideration. And then under the UCC, modification requires no consideration but must be made in good faith. We saw that earlier. So consideration, we saw that consideration is a bargain for exchange of legal detriment or benefit. Past consideration is not consideration. A promise to perform a pre-existing duty is not consideration. We saw that earlier. Then we looked at Battle of the Forms under UCC-207, which says a definite expression of acceptance forms a contract even if it contains additional or different terms, unless acceptance is expressly conditional. Between merchants, additional terms become part of the contract unless they materially alter the offer limits acceptance, or there is timely objection. So under UCC, additional terms will become part of the contract unless it materially alters the contract, the offer limits the additional terms, or it limits acceptance, or there is a timely objection. Perfect. We're getting there, almost done. Then we looked at acceptance, and we saw that acceptance may be by promise or by shipment of goods. We saw that shipment of non-conforming goods is acceptance plus breach. So you accept and then you sue for breach, unless the seller gives a notice of accommodation. So shipment equals acceptance. If you ship it, then it is acceptance. But it is acceptance and also considered breach. Okay, so and then we looked at the common law rule, which is the mirror image rule. Acceptance under the UCC is the Battle of the Forms, right? And we saw that Battle of the Forms, yes, the parties can accept by promise or by shipment of goods. Shipment of non-conforming goods is an acceptance and breach unless the seller gives notice of accommodation. Or Battle of the Forms, as I mentioned earlier, has to do with acceptance, even if certain additional or different terms were added, right? When we saw that for merchants, additional terms may become part of the contract. Okay, so at common law, acceptance at common law. At common law, acceptance is an unequivocal assent to the terms. Under the mirror image, acceptance must exactly match the offer. Under the mailbox rule, acceptance is effective upon dispatch, while revocation is effective upon receipt. Then we saw termination of an offer. We said an offer can be terminated by revocation, rejection, or a counteroffer, a lapse of time, death or incapacity, and destruction or illegality of the subject matter. And we said revocation is effective upon receipt by the offerer. So if the rejection is sent in the mail and not received yet, it's not effective. So there's no revocation. But if it is received by the offerer, then there is by the offeree, sorry, then there is revocation. All right. Then finally, we're looking at the last big topic is offer. And we saw that offer is a manifestation of present intent to contract with definite and certain terms communicated to the offering. An offer is a present intent, or is a manifestation of present intent to contract with definite and certain terms communicated to the offering. An invitation to negotiate is not an offer, and we also saw that essential terms must include the parties, the subject matter, the price, or the quantity. Also remember that UCC gap fillers would fill where the certain terms are missing.